I'm delighted to be joined today by Robert Niles-Weed from VILE. He is an associate in the complex commercial litigation department in New York. And when I saw the impact of Chapter 11, I thought it would be great to get a US perspective on how this piece of legislation or potential legislation borrows from the American legislation. And Robert's particularly well placed to assist with this because after obtaining his JD and MBA from Harvard and a stint of clerking with various judges, including Elena Kagan, he now deals, as I said, with complex commercial litigation. And his practice is focused on appeals, especially in the bankruptcy context, and high stakes motions practice and issues on appeals at all levels. So I'm really grateful for his enthusiasm and the insight he's given in preparing this presentation. And it's a pleasure to have you with us, Robert.
Thanks for having me.
So in terms of what we're looking at then, the legislation is still progressing through Parliament at the moment. It was first introduced on the 20th of May into the Commons. All of the readings took place in one day. There was no real discussion at that point on the details of it. Was then introduced to the House of Lords with no substantial amendments, and there was a second reading on the 9th of June with a surprise intervention from Lord Hope, which was the only real point of comment at that stage. The committee stage took place yesterday, and it's looking like there'll be a third reading on the 23rd of June. So the hope was that this act would already have been enacted by now, so we would be discussing the act rather than the bill. And I'm sure the government would also have preferred it to have progressed a little more swiftly through Parliament as well, given that it deals immediately with the fallout of COVID-19 and the original long stop date of the end of June. Would obviously that obviously becomes less important as time goes on, although that can be extended, and that's a point that we will come to look at towards the end of the presentation. The possibility then arises that there will be some more ping pong between the House of Lords and the House of Commons, and then it will go back to the Commons, and there will be substantial amendments. However, we think that's probably unlikely, because that stands somewhat in contrast with the guidance and explanatory notes that have already been circulated by the government, and all of that is progressing on the basis of the bill as it stands. So for the purposes of today's talk, it's probably what we're talking about in the bill is probably what's going to be in the act as well, but everything obviously has to be delivered with the caveat that things may yet change, and they may change substantially. So over to Robert then to discuss the outline of the talk.
Yeah, so as Sam was saying, the presentation last week, part one, covered more of the nuts and bolts of the legislation, and in particular, COVID-related measures. Recommend watching that video if you haven't already. Here, we're trying to step back a little bit and put the legislation in a bit of context, trying to think about, in particular, which effects signal long-term shifts for British insolvency law, for UK insolvency law, and then providing comparisons and contrast with elements in US Chapter 11 that the new legislation appears to be borrowing from. We're hoping that Sam and I can sort of structure this as somewhat of a dialogue between the two of us, where Sam is primarily discussing the new legislation, and I will be contributing the US Chapter 11 perspective in an attempt, again, to understand which pieces connect to things that exist in Chapter 11 and what the US experience has been with those various pieces of insolvency law. And in particular, we're focusing on three issues: the moratorium, and in particular, the role of the monitor in managing the moratorium. We're talking about schemes and restructuring plans, which seems most closely borrowed from US Chapter 11 law. And then finally, briefly, we'll touch on the issue of ipso facto clauses and the enforceability of provisions in contracts that provide that events of bankruptcy can be a breach of the contract, or in cases where suppliers, for example, are trying to break supply contracts on account of the bankruptcy of the counterparty. So moving on to the next slide, just to preview, but hopefully not entirely give away some of our key takeaways. One issue that we want to keep bringing forward is recognizing that it is somewhat straightforward to bring legislation that looks like Chapter 11 or other foreign insolvency law, but it is much more difficult to develop the culture and infrastructure to implement that legislation in the way that it works elsewhere. So in particular, a tension that I think will come through in our presentation is discussing the very strong culture towards giving debtors a fresh start and rescuing companies in bankruptcy that sort of undergirds much of US bankruptcy law, and somewhat more of a skepticism on your side of the pond towards managers of insolvent companies and the ability of a company to restructure itself through insolvency. On the issue of the moratorium, we compare it to sort of the most close US analog, which is the automatic stay in bankruptcy, and discuss how it is somewhat more limited in its availability and its scope relative to the US automatic stay. Then on schemes, as I sort of suggested earlier, we think here there's potential, and then there's a big question of whether that potential will be realized, but potential for meaningful change to the way insolvency law looks in the UK that will potentially make it look a lot more like Chapter 11 in the US, though there are a lot of questions relating to how it will actually be implemented. And then finally, on the ipso facto clause issue, whereas in the US, this is somewhat of a clear standard, there are a lot of details left to fill in the legislation here. And so, as I said, we're hoping that we'll be able to step back and put the legislation in a bit of context to try to understand what represents truly lasting change, what is simply sort of short-term fixes, perhaps related to COVID, and then trying to disaggregate how the system changes, whether changes are simply achieved by enacting legislation, or whether there are deeper cultural and structural shifts that need to happen to actually achieve their promise.
Great. So moving on to look at the availability of moratoriums then. And this is particularly when we look at the period after the temporary relaxation of the availability of the moratorium after the COVID long stop. The first point is that a statement from the monitor is a prerequisite for the moratorium being granted. And we'll come on to a further discussion on slides 10 and 11 of what the monitor does and what the role of the monitor is generally. And the next slide sets out the wording that's relevant here. But what's really important is it does not matter directly what the monitor thinks. The word thinks is the one that we see in Schedule B1, particularly in Paras 3, Sub 3 and 4. And what the monitor needs to do is form a view as to whether the Objective 1 test can be met. And that's familiar to us from what is known as a light touch administration under Para 3, 1B and 1C. The administration regime, of course, will be available where the potential administrator recognizes that the light touch administration won't be achieved. Moratoriums to cases that fall into the top bracket under Para 3, 1A. There is the other question of how likely is likely for the purposes of this legislation. There was a mention in the Commons from Stephen Hammond, the MP for Wimbledon, that this set the bar too high, that it was likely that it would result in the rescue of the company as a going concern. And he suggested the wording of that it could rescue the company as a going concern, although how that actually creates any sort of test at all when it has two levels of hypothetical is up for debate. And guidance could potentially be taken from earlier cases, like the Harris-Simons construction case that I have up on the slide, which is a decision of Mr. Justice Hoffman under the old style administration regime. And in that case, Mr. Justice Hoffman said that likely in that context meant a reasonable prospect of the purpose of the administration being achieved, rather than it being on a balance of probabilities type test. And that's interesting because we already have a moratorium on the statute books in the form of the small company moratorium, which exists prior to CVA in Schedule A. That is on paragraph 6 sub 2 sub A. It is a reasonable prospect test, and that's what's spelled out in the legislation. So it's a little bit curious that the word likely has been alighted on when we already have an example a reasonable prospect test, and therefore a lower threshold already existing. But it seems to us that the test has to be something akin to a reasonable prospect and not a balance of probabilities test. Although it is a bit curious that if the legislation intended to say real prospect, then why not just use those words? It's also difficult for the monitor, we think, for the monitor to be able to gauge when the likelihood ceases. And what the Act seems to envisage, and this is a point we'll come on to in a moment, is that it's unrealistic, really, to expect the monitor to be standing over the shoulders of the director in any meaningful sense. Of course, insolvency practitioners have other cases on and other things to be doing, but it seems to be that is what the Act envisages, that the monitor looks at the information at the beginning, provides the statement that it's likely that it will rescue the company as a going concern, and when that likelihood ceases, that they will bring it to an end under, for example, Section A38. So really, it all depends on the directors keeping the monitor updated. So just from the outset then, it seems like this is quite a high threshold, and the application of the moratorium at all, the accessibility of the moratorium, seems to depend on how willing monitors are going to be to sign off on what is effectively an objective one administration type test. And it's difficult in practice as well for them to know when they will be bringing it to an end. However, it's clear that the intention of the legislation is also meant to set a relatively high threshold and isn't just intended to delay the inevitable for companies that are destined for liquidation or administration apart from the moratorium. So there's a balance to be struck there, and how that's to be achieved in practice will depend on the monitor's approach to that question.
It seems also from the American perspective that it's not only a high standard, but also somewhat of an unclear standard that would readily invite litigation over how likely is likely, where sort of the line is between that, sufficient to continue the moratorium and where it has to be ended. In the automatic stay context in Chapter 11, the standard is quite clear, and yet there is still a lot of litigation by creditors attempting to lift the stay as to particular actions or to collect on particular debts. So I can only imagine that a sort of less concrete, more formless standard, like the one that applies to the moratorium, will invite lots of creditor litigation, at least in the US. I think that's what we would expect.
But said against that is that the moratorium will only last for probably 20 days or maybe the 20 extra days if the directors make that application. So even if you're going to challenge the monitor's decision, that application, unless it's expedited very quickly, is not going to be heard before the moratorium ends anyway. And so one wonders actually if there's going to be much litigation in practice over that question, because it'll be resolved by the time it comes to court. But on this slide, I've also set out the different tests for the court as compared with the monitor. And there's an odd disjunct between the test that's applied by the monitor, where they need to provide a statement saying that it's likely that it will rescue the company as a going concern, but where the company is subject to a winding up petition, the test that the court will apply is that it's likely to result in a better result for the company's creditors as a whole. So that looks like an objective 2 or possibly even 3 administration. But that is not the test that applies where an extension is sought from the court. So it's a little bit curious to me that there are different standards applying here, both vis-a-vis the monitor and the court, and also when the company is subject to a winding up petition. What is it about a winding up petition that particularly justifies a lowering of the threshold for the purposes of the moratorium? The other issue that crossed our minds when we were preparing for this presentation was that the duration of the moratorium seems rather short. The original proposals that were suggested as long ago as 2010 were looking at 3 or even 6 month moratoriums. And there was an amendment tabled in the Commons for an extension for 30 days instead of 20, which wasn't discussed, and that didn't make it into the House of Lords. And it seems to us that by having a 20 plus 20 model, it's unlikely that this will achieve a rescue, except for in perhaps the most obvious cases. And it does also suggest that when we compare it with the Schedule A1 moratorium that already exists, and we look at how unattractive that has been generally. It may well be that the moratorium ends up being both rarely accessed for the reasons that we've already talked about on the test, but also rarely accessed because of the duration and because of the inability to actually rescue the company within that time. And there are two possible extensions to that, which go beyond the 20 plus 20 model. The first is where you have an extension with creditor consent. And that seems unlikely to us to actually occur in the majority of cases, because why would the creditors choose to delay their recovery? And that also raises the age-old problem of friendly creditors. And this is an age-old problem. I was reading the other day about the first model of creditor compact was introduced into the English law by a statute of 1692. But the legislation didn't live up to expectations and was repealed only 6 years later in 1698, because inflated claims were continually received from particular creditors, thereby imbalancing the decision process. And there's an additional problem here in that the convening of the meeting with creditors is to be presided over by the directors, not by the monitor. And it's actually the director's decision as to whether or not a vote is connected. And that's on the basis of the draft rules that were only circulated, I think, in the last couple of days. And so there may be some change on that. But it seems that there is a real risk of friendly creditors being able to get themselves involved in the process and extending for much longer. And of course, those would be challenged because of the longer extension. The other possibility is on court extension. And this is a more interesting perspective in terms of, and I'll come back to Robert on this in a moment as well, because it depends really on how the judges approach the issue. And if they continue to adopt the sort of creditor first type approach that they currently do, then one can see the judges will say, well, we'll grant an extension perhaps of another 20 days if the application is made. But there is a possibility that the judges who deal with these sorts of application will treat it perhaps more like an admin extension, granting a further year perhaps, or looking at it from a more debtor-friendly perspective. So Robert, how does this compare then with the automatic stay?
So it is, here are some sort of high-level comparisons. I mean, first of all, the automatic stay is integral to the Chapter 11 process. It, true to its name, takes effect automatically as soon as the bankruptcy is filed, and there's no access to the automatic stay outside of the bankruptcy process. So there's no sort of freestanding moratorium or stay that you can seek under U.S. bankruptcy law, independent of actually going through the entire Chapter 11 process, which reflects exactly what Sam was suggesting, that I think the automatic stay, at least in U.S. bankruptcy, is designed to encourage enough time to facilitate actual reorganization. Because if you're coming into bankruptcy without a plan, we'll put prepacks to the side for the moment, it takes months, if not years, to resolve a free fall bankruptcy and emerge with a genuinely reorganized capital structure. So the automatic stay, as a result, lasts for the full length of the bankruptcy proceeding. This can currently, under US law, can be extended up to 18 months by the court. That was used to not be limited in that way. But in, I believe, 2005, our law was amended to put a sort of finite cap on the amount of court extensions, which, as Sam said, is, I think, an open question as to the moratorium, given that it seems like judges have more flexibility to continue extending it, though obviously the presumption is that it would be much shorter. And then as to the sort of scope, as I said, it covers basically everything against the debtor that arose before the bankruptcy filing. And it is possible as to specific actions to challenge the stay and seek to have the stay lifted in particular cases, but there is no sort of way to defeat the automatic stay in the same way that you might be challenging the standard for its applicability in the moratorium context. So the automatic stay is sort of much more connected to the bankruptcy process and much more designed to help facilitate reorganization in the US context that it appears the moratorium is here.
And I think that's one thing we will see where a super scheme is being posited, that an application to a judge in that case to allow the moratorium to continue until the super scheme can be approved would seem quite a sensible way of approaching it. And that that in itself appears to then take on more of the characteristics of Chapter 11, because you have the purpose of the moratorium is to allow the scheme to be affirmed or crammed down, and we'll come on to talk about that in a moment, and not to have creditors interfering with the process while it's going on as much as can be done under the moratorium.
I think that's right. And it as a result is difficult from the US perspective to imagine the sort of freestanding moratorium or what an automatic stay would look like disconnected from a bankruptcy proceeding, because it is hard to imagine what it will achieve other than sort of the most immediate, most temporary relief, and will not sort of facilitate robust reorganization. And so coming on to this slide, this suggests that the moratorium, as compared to the stay, adopts more of a creditor-first approach. As I've been saying, the automatic stay in U.S. bankruptcy is an extremely strong power that the debtor is able to invoke by filing a bankruptcy petition, and it sort of pushes all creditors away from the courthouse door in a way that the 20-day moratorium seems to be somewhat more deferential to creditors seeking to collect. And it is a 20-day period, though there were initially amendments that were ultimately tabled, pushing it to 30 days, which again suggests that more creditor-friendly, less sort of debtor protective approach to the moratorium relative to the stay. And as sort of relatedly, it offers little possibility for actually trading out of insolvency. It is close to impossible, again, unless you come into the moratorium or a bankruptcy with a prepackaged plan, to achieve from a free fall bankruptcy a full bankruptcy plan in 20 or 40 days. And Sam, do you want to say a few words on the availability of debtor in possession financing?
Yes, well, actually, this came out of a question that was raised on part one of the webinar, which I thought would be well addressed at this point in the presentation. The effect of section 851 sub 2 is to introduce a new section 174A and amend section 175, which are the provisions on preferential debts. And the effect of it seems to be that when new creditors are found and new creditors injected into the company, that will take priority. It takes priority even to the expenses of the monitor, and of course the expenses of the liquidator would rank lower than that as well, which is interesting, because I think there's what would be described in Chapter 11 as debtor in possession financing is essentially the same thing as I understand it, but it's odd because it even seems to outrank secured creditors on the basis of what is proposed in the legislation at the moment. And just addressing the last point on the distrust of directors, I mean, it's slightly crazy to us, I think, in the UK or in England to look at the way that Chapter 11 works, and the directors can, as I understand it, file a document with the court, and that prevents all creditors from making any progress with their claim or putting the company into liquidation. And you're saying that can apply even up to 18 months, and there's no involvement of anyone else in that process. And this is where I think we can segue into the role of the monitor. It's a real it's unique to this process. There's no parallel in the US proceedings, although I think Robert, when we were talking about this, you said there is some residual scope for trustees and examiners, but that's only really where there's a suspicion of wrongdoing or where there's government money involved, as I understand it. And the position of the monitor in this jurisdiction seems to be a halfway house between giving the directors free rein. The directors will remain in control of the company rather than handing over the control of the company to the liquidator or the administrator acting as agent. And so they're seen probably as being more like a nominee or a supervisor than a traditional office holder. And there's also a parallel here, interestingly, with the role of special manager we've seen in recent cases like Carillion and British Steel, where the official receiver takes over in the winding up, but then special managers are engaged on a sort of an advisory basis, but in practice they would seem to be in control of the process, and so they take on more of the characteristics of an administration, or perhaps one could say even something similar to a moratorium, because the company is still trading at that time. And the reason for having a monitor at all seems to be that there is this distrust of directors in this jurisdiction, that when a company fails, the reason for it failing is because the directors haven't managed the company properly, or they've been helping themselves to the assets of the company. And I'm sure we've all come across cases where that is indeed what's happened. But the American approach, as I understand it, Robert, is that there's a lot more trust in the way that companies are run, and there's an expectation that companies will fail from time to time. Would you like to speak on that maybe a little?
I think I may have been muted there for a second. I think we start from the presumption that most bankruptcies are caused exogenously, whether due to sort of structural changes in various industries or a particular shock. And it is less on account of particular malfeasance by the company's management or directors. We do also have cases where bankruptcies are caused by directors or managers misbehaving, but we sort of presume that the current management and directors are best positioned to help the company restructure because they have specialized knowledge about the company itself and about the industry. So it is often the case that management changes before and after a bankruptcy, but it is still deferred to the company management itself to continue running the company and continue designing the plan of reorganization. So I think there's, as Sam mentioned, there are some situations where the court can appoint outside officers to make sure that the company is behaving properly. But it is quite foreign to us to imagine somebody like a monitor coming in to have that level of supervision over the debtor in possession, separate from the court, who plays a slightly similar role in being required to approve certain decisions that the company is making, but a much more hands-off role relative to the monitor, because it is the company's management and directors who maintain and control of the company.
Thank you. So the monitor's role then, as we can see it, is more or less standing over the shoulders of the director, asking for information when they need it. And the presumption is that the directors, and this is what the Act sets up, the presumption is that the directors will be passing relevant information to the monitors as the moratorium continues. And so the monitor is entitled to rely on the information that's given to him or her. And this gives rise to the first of two ways in which the monitor is quite well protected. The first is that the monitor is expressly allowed to rely on the information given to it unless there are reasons for not relying on it. Although there's a curious provision in itself, because what facts would one have to be aware of that would put the monitor on notice if the only information that the monitor has been given to it by the director before the monitor produces the statement to begin the moratorium? And there might be some guidance there in terms of the role that nominees play in terms of the information that they can expect to receive from directors and indeed from debtors themselves in the IVA context. But this gives rise to an interesting question, because if we are starting from the presumption that it's a step too far to allow directors to simply file documents themselves and to get the protection of the moratorium, then it's an uneasy mismatch to suggest that the director can pass the information to the monitor submits the statement to the court, and the court is entitled to rely on the monitor as an officer of the court, and the monitor, under the statutory presumption, is entitled to rely on the information provided to it by the director. So it does rather raise the question of, well, why not just have the director file the information with the court anyway, and the director will be liable further down the line under section A44 in any event, or indeed under section 212 in the usual way for breaches of director duties. The second point, and this is a very interesting aspect, is in the provision in section A42 sub 4 sub C, which specifically carves out any possibility of monitors being liable to pay compensation. So monitors do have various criminal offences. There are various criminal offences created in the Act for the monitor failing to notify. But the challenges to the monitor's decisions, and that includes starting and ending the moratorium, will not appear to give rise to an order for compensation. There's a specific protection given there. It's almost an immunity from suit type subsection. And that seems fair enough in terms of starting and ending the moratorium. It's only a 20-day or a 40-day process. And to the extent that the court is involved in extending it, of course, the court will have ultimate oversight on granting any further extension anyway. But it's a little bit more complicated than that, because the monitor is also in charge of certifying when a sale of company property takes place, for example, on the basis that it will benefit the company. And that's quite similar to where we see validation orders taking place under Section 127 in the current regime. So we can have a situation where the monitor could sign off on the disposal of a significant amount potentially of the company's property, which could be done with relying purely on the statements given to it by the director, for example, or where the monitor has not conducted their own evaluation, or they've been negligent in the process. The company loses out as a result, the creditors lose out as a result. But it doesn't seem that even in that case, it would be possible to bring a compensation claim against the monitor. And one could think, well, maybe there's scope here for Section 212, a claim to be brought there against the monitor. Well, there's no suggestion in the legislation that is going to be amended. And indeed, that would seem to contradict Section A42 sub 4 sub C anyway. And it does indeed seem to be the purpose and intent of the legislation, because there is no similar protection given to directors under Section A44, rightly so, and unsurprisingly, we would think. And there's also similarly no safeguarding under the nominee provisions under Schedule A1 in para 27 sub 3. That simply says that the court can make any order it thinks fit, including reversing decisions and so on of the nominee. But it doesn't have the carve out and the protection for no compensation. So this is an interesting point to keep tabs on as the bill makes its way through the House of Lords, and indeed if it comes back to the House of Commons. And it'll be interesting to see whether this makes its way into the Act. And indeed, if a monitor is negligent in future, whether the court finds some sort of workaround to this, whether it's seen as a claim of the company that it has against the monitor, is unclear. But it would seem to be quite tolerably clear at the moment on the face of the legislation that the monitor does have protection which no other office holder is entitled to. So I think we're going to move on to talking about schemes under Part 26A, which I've borrowed the description of super schemes. Robert, are we just stealing Chapter 11 here?
That's a great question, and I think somewhat remains to be seen. I think the super schemes structure is the closest analog to Chapter 11 that has yet been adopted. In particular, it expands to include secured creditors, which is de rigueur in Chapter 11, where secured creditors and unsecured creditors are treated equivalently for the purposes of voting and plans. To be sure, there are separate protections for the interest and security that secured creditors hold, but there is not sort of a hard line distinction between the way secured and unsecured creditors are treated for the purposes of adopting, voting on a plan, and cram down, again, putting to the side separate protection for their security interests, which, to my understanding, Sam, is a very big departure from previous norms of UK insolvency law. Is that right?
Yes, and I've got on the slide there Section 269, which is about petitions, and where you if you're a petitioning creditor, if you have a secured debt, that cannot give rise to a petition. And that's just a way of illustrating that if you're a secured creditor, normally the response of the legislation is you cannot participate in the insolvency proceedings. That's not what proceedings are there for. The way that the security will normally be treated is that it sits outside of the insolvency altogether. So it is a radical departure, and it's certainly something that we haven't seen before in CVAs and so on, especially with the ability of the unsecured creditors to cram down or even cram up the secured creditors. And as I understand it, that's quite a big difference, even from Chapter 11, this concept of cramming up and the absolute priority rule and things like that.
Yeah, so generally in Chapter 11, the absolute priority rule requires a strict waterfall such that higher priority creditors are always compensated basically in full if possible before lower priority creditors are able to get anything. That sort of another departure that we were discussing is the voting requirements required to confirm a scheme or a plan. In Chapter 11, voting occurs by creditor class, and there can be some fighting around the margins about how exactly classes are carved up. But as to each class, Chapter 11 requires 2/3 and the full amount of the value of the class and 50% or 1/2 in number to approve a plan. It's in the new insolvency law, the scheme provision requires 75% in amount, but has no numbers requirement. Now, these voting provisions are relevant sort of standing on their own, that it seems to require greater approval under 26A than it does under Chapter 11 for a class to approve a plan or scheme. These proportions are also quite relevant because they end up dictating what in practice is required to accumulate a blocking share to stop a plan from going through, where in the US, usually a distressed investor accumulates a third plus one in the amount of a creditor class, they're able to sort of force the vote in that way, which in the UK context seems even more straightforward because you'd only have to accumulate a quarter plus one of the voting class in order to have that. And then finally, the last bullet point on the slide we wanted to talk about is understanding how the scheme compares to sort of the general idea of a relevant alternative, which is the comparator required. In the US, when you're looking at confirming a plan, the sort of sole relevant alternative is what is available under a liquidation. Because in the US bankruptcy law, there's sort of two principal chapters that apply. Chapter 11 that refers to reorganizations through a plan of reorganization. And then Chapter 7, which allows for a sort of court-facilitated liquidation. And so always the question in confirming a plan is whether creditors would be better off by the proposed plan than they would be in the case of a liquidation. And if so, that is one of the criteria to meet to allow to be a plan to be crammed down over disapproving creditors. But it seems like in the UK now, there's somewhat more openness to considering possible alternatives. That's right, Sam?
Yes, and it's a little bit unfortunate possibly because it opens up the question about, well, one party may say the relevant alternative is that there's going to be a prepack or that an administration is going to take place and a part of the company can be sold. And in that case, it might start looking a bit more like the super scheme that's being proposed. The advantage of the US alternative of liquidation is that it should give a relatively clear answer. You look at the relative priority of the creditors, you look at the assets of the company, assuming that there's no contest over valuation or no substantial contest over valuation, it should be fairly easy to work out who gets what. And the problem with using the relevant alternative is that it gives another stage to the debate at the point when the court is deciding whether or not to cram down. And so that's another judicial determination as well that will be made under Section 901G, whether to impose the plan even on those who have resisted it. And so that doesn't give the best prospect for a plan necessarily succeeding, because different parties may have their own impressions about what the alternative will be. And indeed, if one party wants to block the cram down from going ahead, then they might want to raise those arguments.
Indeed, in the US context, there already is often quite a bit of fighting over valuation with debtors and even various classes of creditors presenting different valuations that will ultimately sort of maximize the likelihood that they hit the fulcrum security where the value runs out and they end up sort of owning the company out of bankruptcy. So I can only imagine that layering on additional alternatives will only sort of multiply possibilities of litigation on this issue.
So we might see that as something of an unfortunate provision then in the circumstances. Although I wonder if the reason for this coming about is because in Chapter 11, the only real alternative, as I understand it, is liquidation. That's what you're looking at. You don't have these range of alternatives that we've accumulated in the UK and in particular in England over the last, well, since the 1986 Act was introduced. And so we've been moving closer and closer to a Chapter 11 model, but we've never really taken the plunge in terms of coming up with a method of schemes that binds secured creditors. And so it would be perhaps a disservice, I suppose, the argument would be to not take into account those other alternatives, those shades between a restructuring and rescue of a going concern under Part 26A and liquidation at the other end. In practice, I think it's likely that liquidation will be the alternative that everyone works off. But I can imagine if one wanted to prevent a scheme from going ahead, there are arguments there that you can run and really throw a spanner in the works if that's what you want to do. So in terms of where this leaves super schemes, I suppose the first interesting question is, where does this leave CVAs and prepacks? We know that CVAs are not particularly common or popular way of dealing with an insolvency process. I've got some statistics there from the Insolvency Service website. It works at about 2% of corporate insolvencies in 2019. And also, where does this leave prepacks? And this might be a positive outcome of super schemes, because the contention about prepacks has never really gone away in this jurisdiction. And I think it's fair to say that there is more skepticism about them than there is in the US, although that's only based on sort of an anecdotal, in our discussions. But it seems to me that if you can have a process which involves all of the creditors and that they're aware of what's going on and they can vote on it, even if they're outvoted, they can have some visibility on the process that's taken place, rather than the unsatisfactory nature, or sometimes unsatisfactory nature, of a prepack, where everything is negotiated before the administration is appointed, and then the creditors will only discover after the sale has taken place and the administration started that this is what's been going on in the past. So it may take some of the pressure off of that more contentious aspect of the administration regime as well. But ultimately, I think we come back to the same point that we raised at the beginning of our talk, which is that whether or not this succeeds really is a question of the culture, and whether there will be a culture of agreeing to these things. Whether this is the first thing that the creditors think of is, well, hang on, instead of winding up the company, why not apply to put forward a restructuring plan? And then the other issues that we have on the slide, Robert, I think you were going to cover those.
Absolutely. So I think that's exactly right, Sam. It is well and good to have legislation that facilitates this type of reorganization, but it only really matters if people use it and think that it's a viable path towards reorganizing the company as a going concern. And relatedly, something that we think about with any change in insolvency law is what the reaction from lenders will be, who are now sort of forced to price in the possibility of Part 26A in a way that they would not have before. So we're sort of trying to understand how this sort of inflects the behavior of creditors who, may amp up covenants in response to this possibility of an additional change, or might otherwise demand additional loan terms to compensate for this risk. And then the other sort of significant uncertainty is what judges will do when they are interpreting and enforcing the law. In the US, there's a sort of perception that bankruptcy judges are overwhelmingly pro-debtor and sort of do whatever has to be done. This is sort of in the pejorative characterization, but do whatever has to be done to get the reorganization through. Of course, that characterization is disputed, but that is sort of generally the norm of how the American system thinks about the role of bankruptcy judges. And in the UK, it seems like the creditor first culture and approach might also inflect the way judges are approaching these questions. And so it'll be interesting to see whether the pro-reorganization mindset that undergirds a lot of American bankruptcy law and judicial practice will slowly make its way across the pond.
Yes, and I think it's interesting in the context of schemes because judges will be coming at them from, I think, from their general practice with Part 26, which is the current schemes of arrangement regime. And in those sorts of cases, if everything's agreed and it looks like it's going to work and it'll be effective in the relevant jurisdictions and so on, the practice of the courts, as I understand it, is generally to affirm these plans. Whether the judges who are dealing with these cases where they're effectively having to make their own decision about whether or not to cram these down, whether they're fair and equitable, is a big question. And whether they start approaching it more as a scheme or whether more of an insolvency process when it's really a bit of both, will be an interesting thing to see. The other question I had was about the international recognition point, and I don't want to go into this in too much detail, but it's interesting that schemes of arrangement currently are not included in Annex A to the European Insolvency Regulation. And the European Insolvency Regulation, of course, will potentially become of less importance due to Brexit anyway. But one would hope that we would have something similar on our statute books after we leave the European Union that recognises incoming insolvency proceedings from the EU 27. There's a query here whether super schemes should be included in Annex A, whether they would be the type of scheme where, or the type of process, I should say, that does achieve automatic recognition in the EU as well as in this jurisdiction. And it's interesting that the timing of this as well, although obviously COVID-19 is what prompted the bill to come onto the radar, despite having been sat on the back burner for a few years. It's interesting that it's as Brexit is going on that we're having this discussion about moving more towards an American model of restructuring. We're taking these cues from Chapter 11, and I wonder if this is part and parcel of an Atlantic pivot. It's interesting as well that both countries, the UK and the US, have adopted and ratified the UNCITRAL model law. And so it seems to me that it would be fairly clear that a US bankruptcy judge would give recognition on an application to a super scheme under Part 26A. But I also wondered if there was scope for automatic recognition, given the similarity in the processes, whether that would be something that could theoretically happen in the US. Now, I accept it's probably unlikely that the US is going to be considering any kind of legislation along those lines anytime soon. But it's an interesting thought experiment. You know, why not have automatic recognition in the way that we have in the EU between member states applied to the US, particularly where those processes are as similar as they are.
And I think it will be interesting to see once the first wave of Chapter 15 recognition petitions in the US come through involving Part 26A schemes, how the courts approach them and how they think about them, and looking at them as much more Chapter 11 like, I can imagine would only streamline the recognition process. So it will be interesting to see, and I think we'll see it probably soon, how courts in the US are treating Part 26A schemes.
Great. Ipso facto clauses. This was the last topic that we wanted to cover off today, except for the point on the delegated powers, I think, on the Secretary of State. The ipso facto clauses are really designed, and I think Simon covered this in the last webinar last week. They're really a way of reading down or disapplying clauses that say, if you're in financial difficulty, we will treat that as a default in and of itself, hence ipso facto, and we can bring a claim for example, the full amount of a term of hire or something like that. Now, the problem with ipso facto clauses, although intention is a good one. It seems to me that their efficacy is only really going to be important when you have a longer stay. So in Chapter 11, if you have a ban on ipso facto clauses and you have a long automatic stay of, say, a year, then you can see how that can allow for a trading out of difficulty. It balances things in favor of the debtor. But how this will work with moratoriums of just 20 or 40 days is a bit more dubious. And there's also the question that what if we have a supplier who decides not to deliver goods because the supplier is not sure whether or not they're going to get paid? The answer is that it will give rise to a claim against that supplier, but from a company that may well be heading for liquidation anyway. And if we have a supply term that says payment is to be made in 30 days, for example, well, it's neither here nor there really how long the moratorium lasts, because if the moratorium is shorter than the term for payment, then one can see there's not really any incentive on the supplier at all to do business with the company. Now, if the company can offer payments up front, then there's no reason why the supplier wouldn't supply. But if the term is for deferred payment, I think there's a real question there as to whether the ipso facto clause will achieve anything in practice. One would hope that businesses would honour their contract terms anyway, but the commercial reality may be quite different from that. The other way that the ipso facto clause exception is reduced in terms of its efficacy is because of the threshold that applies here. Now, the accepted companies are actually quite large. There's what's said to be a small company exception in the legislation, but the cutoff point is actually a £10.2 million turnover, £5.1 million balance sheet, and a 50 employee cutoff. I wondered why it was a £10.2 million turnover, and I wondered if that had something to do with a personal interest of one of the MPs who was involved in drafting the legislation. But anyway, the type of company that's going to be included in that is obviously going to be on the larger end of an SME, and potentially outside of the SME category, and certainly not a tiny company exception. And the other question is about the other two points at the bottom of the slide. When an ipso facto clause arises, the creditor is prevented from doing any other thing, and that's the word that's used in the legislation. There's a question mark there whether that includes calling on guarantors to make payment, or indeed other companies within a group if there's a joint and several liability to make those payments. Now, our view is that the any other thing only relates as between the creditor and primary debtor, but it's unfortunate that that is not spelled out in the legislation. Indeed, that's something that will have to be worked out in due course. And the question of hardship as well is also a somewhat amorphous term in section 233b sub 5 sub c. And the idea there is that if the supplier itself is having financial difficulties, then there will be no there'll be an obligation on it to provide the supplies. But that does rather raise the question of, well, what are financial difficulties? What's the kind of solvency test that we're looking at? And indeed, that will all need to be worked out in the courts. We would hope to see a narrow construction of hardship if the intention of the moratorium is to preserve the debtor company. But again, if judges adopt that sort of creditor-focused approach that they currently have, then there's a possibility that it will be interpreted more broadly, and hardship in theory could encompass any type of transaction at all. So we would hope for a more narrow construction of that, but it is by no means certain that that's what will be given to it. Did you have anything to say on this slide, Robert, or should we move on to the Henry VIII points? I
think maybe we should move on in the interest of time because we're coming up on the end of the hour. So just a few points to note here. We sort of began with a disclaimer that things might change from here, and we just wanted to highlight a few other potential ways in which things could still change. First of all, as Sam mentioned, there is the possibility of further amendment to the legislation. There's also the possibility of further legislation depending on what the pandemic and sort of the pandemic affected economic change looks like. From here, I know in the US, we sort of had a seriatim approach to economic stimulus that we're still waiting to see what the full extent of legislative change resulting from the pandemic and related economic consequences will be. And then finally, it was covered last week that the Henry VIII powers in this legislation seem quite broad, and they give the executive substantial discretion to sort of modify a lot of what we've been discussing so far. And this is something that's quite foreign in the US context. Our bankruptcy code is very much code-like. It's sort of set out in the statute books and pretty fixed. It leaves a lot of open questions for judges to interpret, but there's not as much latitude for an executive agency to change the rules and sort of change the game out from under debtors and creditors, largely on the belief that as much certainty as possible that can be provided about what the bankruptcy alternative looks like, the more it will facilitate contracting up front. So I think the goal is to ensure predictability and uniformity, and things like these Henry VIII powers introduce a tremendous amount of uncertainty and risk into what the ultimate effect of the bankruptcy or insolvency legislation will be. So we just wanted to flag those as areas that might undo everything we've said so far.
So some preliminary conclusions then. It seems that the moratorium provisions are probably too limited to affect any change in and of themselves or to facilitate a balance sheet restructuring, partly because they are limited in terms of the availability and their duration. The question about monitors, are monitors really even necessary, especially in light of the judicial oversight that's offered? It seems that they have quite a difficult role to play, and what the statute and what the Act spells out is probably quite different from what will happen in practice. But in any event, it seems that their immunity is a step too far, and we say unjustified. And of all of the changes that are brought about in the bill, it seems that super schemes show the most potential for change, but that in itself will be dependent on a shift in culture and indeed judicial attitudes towards a rescue first approach. So I think that brings us to the end of the talk. It's now 3 o'clock. So thank you all for listening. We will be, I think, staying online for a little longer for any questions. Please pop them in the chat. Yeah, thank you for coming.
Thank you. And feel free to reach out to us by email as well if you have further questions or follow up.